So why is she not testing? This is her third MTR. So can somebody explain?
I knew I was dirty, and I'm not gonna lie. I knew I was dirty. I didn't.
So that still doesn't explain why you didn't report, because you have responsibilities. So you were just not following through on anything. And if you've been in inpatient treatment, they've talked to you about what you need to do in order to stay clean and sober. You just choose not to do that. So I don't know why I should give you 4 years and why it shouldn't be more. But does anybody have an answer for me? What is being asked? Do you know if it would be anywhere in the previous competency evaluations?
From I think it needs to be correct, Judge. I think
Okay.
the last control was at least several months ago, so I think that all we need to do is have someone from UHS help us, but I don't have the list.
Okay.
I know there was someone on the Zoom named Paul, the only person I'm seeing here is Pete Ramos, but it's indicating that he's from CHCS. I thought he said on the Zoom that he worked with UHS. So I think I might need the assistance of a jail liaison from the center or someone from UHS to get this. I did leave a message with Miss St. Clair. She hasn't gotten back to me because I was asking if anyone in custody has been screened and how we can go about doing that. So I'm still waiting for a callback on that. But we have run into roadblocks trying to get this information from UHS, so.
All right, can I have that printout, please? That's.
I think Paul.
Morning, Judge.
Good morning.
That's
How
okay.
you doing, Stephanie?
I'm doing great. How are you doing?
Thank you, Judge.
Thank you. All right, so I think we've come up with a plan to help you. And when I say we, I mean probation, your attorney, and all of the medical personnel. So there's a couple of things that your attorney is going to want to go over with you today.
Yeah.
And if you can talk to him about the information they're requesting, his brother may or may not have access to that or may have it. Because I think his brother may be his guardian. I'm not 100% sure. And so he may have that information.
I can check, Judge, and if not, I will contact the jail liaison and maybe UHS since I have this to see what we can do. Hopefully Ms. St. Clair can call me back, because I was trying to see if she's ever screened someone in custody. And then we'd also have to check with SB and see if Mr. Payne can be transported directly. If he can't be transported, maybe that needs to be his brother or possibly might be some person to assist, but ideally that's where she's just set up.
Okay. And then I don't know if the jail did any type of assessments.
They took the initial screen, but I think the most current and the one that they would want, because it's asking for daily updates in here, would be UHS, because they're the one giving you medication.
All right.
So maybe with this, I can get some.
Okay. All right. Awesome.
I'll check this.
Oh, thank you.
You.
Oh, thank you. And you're looking better too. We're going to try to get you out as quickly as possible. Okay. All right. All right. Thank you, sir.
I'll look in the probation file to see what we have, but
Let's go back.
there are certain medical things that I would not be able to release unless I had some type of subpoena or court orders.
Okay. I'll do a court order. I'll do that right now.
Thank you.
And then you'll get the release. So let me do that right now.
Thank you.
All right. Thank you. All right, Mr. Seeloff, are you ready?
Yes, Your Honor, we're ready. He wants to make an announcement to the court, please.
All right, and what's your client's name?
Eric Guzman. He has 2 charges, possession, by a felon and a drug case.
All right, yes.
I would like to retain the word.
All right, if you want to hire an attorney, then Ms. Ferguson, set this in 30 days. Mr. Seeloff, you're still the attorney.
I understand.
Unless he hires one.
I gave him a card of Mr. Young. He is very good. And so hopefully he can make some arrangements with him.
Right. What date, Ms. Ferguson?
County Court 12 that was reset today because there's a trial. We have an agreement here that once we resolve that, we're gonna come up here and present you a document for dismissing of this case.
All right, go take care of it.
If they're in trial, Judge Huff is in trial.
Okay,
I wanted to do that too, as much, more than you actually. But 6/29 is the reset date. I thought that was, I'm gonna try to do it sooner. I'm at the direction of Judge Huff's fund, Your Honor. That was the date that was given to him and confirmed by me. And it seems like a long time. I am going to reach out and make this sooner based on the wonderful agreement that we have in this matter.
okay.
So do we keep it on 6/29 here also, or?
Yeah. Norma, can you put this on June 29th for disposition?
Hopefully it'll be sooner, Judge.
All right.
All
Once
right.
you sign the reset form, you're excused. Good morning. Have a great day.
Likewise.
All right, thank you.
Judge.
Oh, and defense, just go there first to take care of that before you come up here.
Correct.
Huh. All right, who's next?
Page 3 at the bottom, Adam Vasquez.
Yes, Adam Vasquez?
Apologies, I'm sorry. Yeah, may we approach
Yes.
Mr. Vasquez? Morning, ma'am.
Hello. All right, today's plea deadline date.
Judge, I'm sorry, I was not aware that we were just able to download Discovery.
Okay.
And so, and I know that there is Discovery, definitely, even though I have not been able to go through all the Discovery,
Mhm.
100% the litigation packet for the drugs, we have not received that.
We have not had a motion for the discovery package until now, but I'll put the order in and we'll get it to the defense.
All righty. So when are you expecting on having that?
Maybe about a month. And how quickly we get this back. So really?
It's quick.
Okay.
All right, Norma. Recall this for mid-June for plea deadline date and jury trial.
I can do the 22nd.
All right, we'll see you back on June 22nd.
Judge, may I didn't put this on the note because I didn't realize this hadn't been signed as well. We do have one motion that the state is aware of, and I think they have any disagreement, if minors, that we could resolve quickly. If you
So did y'all want to confirm this?
feel like you're.
Okay. So you're agreeing to everything that's in the motion? Okay.
Thank you, Judge, for
You're welcome.
indulging that. And there's one on the final, there's one granted or denied on that last page.
Thank you.
Thank you, Judge. We got to work on that editing.
No problem.
Thank you.
If you make sure Ms. Ferguson has that.
May I make a copy first? And then?
Sure.
Thank you, Judge.
There's someone in the back.
Thank you. Thank you.
Thank you.
May we be excused? once we
Thank you.
adjourn?
Court is calling 2020 CR 7507 State versus Desiree Garza. Can I have parties announced?
Derek Emmis from Miss Garza.
And are you Ms. Garza? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes,
Are you the same Desiree Garza who was placed on deferred adjudication in 2020 CR 7507 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on May 4th, 2021 for a period of 6 years? Is that you? All right, state.
Violated condition number 2, on or about the 22nd day of August 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. Violated condition number 2, on or about the 18th day of November 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 9th day of December 2025 in Bexar County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. And finally, violated condition number 2, on or about the 30th day of January 2026 in Bexar County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Sure. State will waive the remaining allegations.
Any objection to the waivers?
No objections.
All right, and that's for number 2s. All right, did you understand by pleading true to violations 2, 2, 2, and 2, the court can find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true?
Yes.
Court will find 2, 2, 2, and 2 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke, and sentence to 4 years in the prison. The state will also take into consideration clause number 2026 PF 14573.
All right, did she do any inpatient treatment?
She did, Judge.
Okay. All right, so why is she not testing? This is her 3rd MTR. So can somebody explain to me?
There,
All right, if you want to explain, you'll have to raise your hand and I'll take you under oath. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Desiree Garza.
Ms. Garza, the judge asked you a question, why you were not submitting to the UAs. Could you answer the judge why you have not submitted to the UAs or why you missed them? What happened in your life, why that happened?
I was going through a lot at the time and I knew I was dirty and I'm not gonna lie, I knew I was dirty. I didn't.
So that still doesn't explain why you didn't report, because you have responsibilities. So you were just not following through on anything. And if you've been in inpatient treatment, they've talked to you about what you need to do in order to stay clean and sober. You just choose not to do that. So I don't know why I should give you 4 years and why it shouldn't be more. So does anybody have an answer for me?
Judge, I understand the court's position. She has been a safety. There's been some expense that the state has put out there for her rehab. Obviously, addiction is a difficult thing people deal with, and it's something she has dealt with. One of the recommendations in the probation officer's file was revocation, of course, as well as safety special needs. I guess that's a separate safety program from what she's done before. I've explained to her, judge, that on a revocation, she's going to be repeated from here on out. She'll have a PDC trip. She's not on probation if she ever gets in trouble again. She just assured me that she has a daughter that started in the military, is about to graduate. This boot camp, I'm assuming. She wants to try and put this behind her. Obviously, her track record is not really showing that she's capable of doing that as of yet. We understand that, judge. We're asking the court to consider giving her the 4 years TDC. There's a lot of bite to that because she will be a convicted felon now. She understands that. So she'll try and put this behind her as quick as she can and move forward in a positive direction.
And is this her first felony? And the reason why I asked that, because the plea bargaining agreement, the state was silent on your application. And so the court gave you deferred adjudication. And at that time, they were asking that you be sentenced to 2 years in the prison.
Based on looking at the history, Judge, I do not see any, there's not county convictions. I do see, however, there have been several arrests that have been.
All right, this is what the court is going to do. The court is going to grant the motion, find you guilty, revoke, sentence you to 5 years in the prison. Give you credit for any time served. There's to be no unsupervised contact with minors, no residing in households with minors, therapeutic community. And I will give you credit for any successful inpatient treatment completion.
Thank you, Judge.
All right, did you? Yes.
She has a monitor on her ankle as well still. I think the court ordered it from what she shared with me. This RMS
They
monitor.
got her they have her with a monitor and while she's at the jail?
Yes, and I've never encountered that before, Judge, but the deputies told me that it happens more often than you thought. I thought I could just call pretrial GPS and have them come remove because maybe they didn't need the monitor for someone else yet. But she's sharing with me that is actually through, which I think is something you might have ordered on her last MTR.
Okay,
You had ordered it when I got released from St. Pete, like relapse.
all right.
Yes.
Ms. Abrams. Did we order a monitor for her?
Judge,
Are they letting you charge the monitor at the jail? All right,
it was partially done, yeah, after last.
all right. I'll order removal of the monitor.
Thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you will need to speak to an attorney. Do you understand?
Yes.
And also, you all are taking something in consideration, correct?
Yes, Judge, I emailed the intake.
All right, so, and also for the record, taking in consideration 2026 PF 14573. All right, we can go off the record. Here's the thing. If you don't change your life, you know what's going to end up happening? You're going to end up going back and forth to prison, or you may end up somebody identifying your body, because you never know what you're going to get when you're taking drugs.
Yes, ma'am.
When you're released from, take advantage of the therapeutic community. The therapeutic community doesn't increase the time you're in custody, but it's designed to help you. So what will end up happening, I've ordered it, they're going to see it on the judgment, but I don't have jurisdiction to force you into that program. So you're going to have to ask for it as well. When you're released from prison, the first thing you need to do, go to lifetime recovery, go to felony drug court. And this is why I'm suggesting you go to felony drug court. Felony drug court will have all the resources for you to get you in an inpatient treatment facility. Do you understand?
Yes.
All right. I don't want to read about you on the news. Okay. All right. Good luck to you.
Maybe excuse Judge.
Yes. Who's next?
Okay, 6, Linda Fargo.
Linda Esparza. Yes.
Back in November. I had not seen her, and it's my understanding she picked up a new case in March.
Mhm.
I was under the understanding she was out on bond. She is not. She's incarcerated, and so they were gonna bring her up, and she just had a medical episode, so
Okay.
she's on her way to the hospital. I was asking for a reset.
All right. Ms. Ferguson, on this case, I'm going to give you a date in June, but if you want her brought back sooner, or you think she can be brought back sooner, just let us know. I'm going to put it at the end of June.
That clears me of everything, and I'll try to get a hold of her when she's out of the hospital.
All right. Court is calling 2026 CR 003283 State versus Stephen Limon. Can I have parties announced?
Rene Munoz on behalf of Mr. Limon.
And are you Mr. Limon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Lamone, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? Court will find that the state is in compliance with discovery. Mr. Lamone, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lamone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $0 fine. The state is recommending community supervision. This is running concurrent with 2025 CR 007431. Restitution, if any, and 2-year driver license suspension or affidavit of non-driving. Did you understand that to be your plea?
Yes, Your Honor.
Defense state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, 10 days in the Bexar County Jail, participation in the felony drug court, DWI intervention, VIP live, and ignition interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
To the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, and most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm assuming he's already been accepted into felony drug court?
He has, judge, in that case that is to run concurrent is also a case that he's currently on.
All right. So here's the thing. And I know I probably told this to you before when you were placed on probation. You can't drink alcohol, period. And if you continue the way you are, one, you're going to end up destroying your liver. And then you're going to be on some site asking for somebody to donate a liver. You're going to destroy your kidneys, or you may end up killing someone. You understand? And I understand that you have military service, but any issues that you have that's related to that, you're going to have to start addressing those and not through alcohol, because otherwise it's not going to end well. You understand?
Yes, Your Honor.
All right, this is what the court will do. The court is going to sentence you, as previously stated, the court, I'll state you may be excused. As previously stated, the court is going to find you guilty. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. There's to be regular random UAs. Regular reporting by Zoom or in person. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. He's to remain in custody counsel until released by felony drug court.
Yes, Your Honor.
There's to be a 2-year license suspension. This is to run concurrent with 2025 CR 007431. 200 hours of community service restitution. I'm going to deduct an hour for every sober support meeting that's completed. Field visits 1 time per month until further notice. DWI intervention, DWI education, VIP live, restitution, if any, to Paul Sparks. Ms. Ferguson, I need a restitution date. State, how long will it take to get restitution?
But 2 weeks is fine.
All right, can you set it 3 weeks? All right, that'll be May 26th for the restitution hearing. And I assume they said in here that they would allow an affidavit of non-driving, but what I'm gonna tell you, if you have access to any vehicles, like it's in your parking lot, I don't care if it's somebody you're living with and it's their vehicle, then for the court, you have access to that vehicle and that vehicle will need ignition interlock. You understand? All right, so.
Your Honor, one quick question regarding the restitution hearing. If he is in an inpatient facility, can he appear through Zoom?
Yes. So that's ignition interlock. Full term. Or affidavit of non-driving with proof of no access to vehicles. And probation, I know it's hard for people to prove a negative, but once you all go to the home, you'll be able to see if he has access to vehicles. So it's ignition interlock full term or affidavit of non-driving with proof of no access to vehicles. And that will be with a portable alcohol monitoring device. 10 days in the Bexar County Jail as a condition of probation. Probation, is there anything else? Is there anything else you need from the court to be successful? You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so here's the thing. You got to figure out why you're using, and you've got to figure out what works for you to maintain your sobriety. And if there are people who are around you who realize that you shouldn't be drinking, and they tell you, oh, it's just one drink, those are not your friends, and you're going to have to cut them off. Your sobriety needs to be your #1 priority, okay?
That's good.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome.
Your Honor.
And defense, what are you requesting?
Judge, on behalf of Mr. Peterson, because he has been on probation since 2023, and he did successfully complete one of the programs, we're asking the court to give Mr. Peterson a sentence of 4 years.
All right, the court stated the court would give 5 years. All right, the court will sentence you to 5 years. Are you waiving your right to appeal?
Yes.
All right, the court is going to sentence you to 5 years in the prison. Give you credit for any time served, credit for any time served for successful inpatient treatment completion. Court will request the therapeutic community. There's to be a 2-year license suspension. All right, probation, is there any, and there's a $2,500 fine. Time and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, that was.
Yes.
All right, because you waive your right to appeal, you do not have the court's permission to appeal because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, when you get released, you had better find a treatment place. Otherwise, you're gonna be right back here with another DWI. And it may be worse than this. You may end up killing somebody, okay?
That's fine.
All right, and the reason why your range of punishment beginning with was 2 to 20 was because of the enhancements for your previous DWIs. You're gonna have to change, all right?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome. Oh, I'm so sorry. Here it is, the court summary.
Judge.
On Ms. Kilpatrick,
Mhm.
she did inform me that items that she's going to be positive for is for marijuana and for Adderall. She said she does have a prescription for both.
It's just
Did you-
with, so I don't know. You want to try to the drug test?
25 CR 009982 and 2025 CR 009908. State versus Troy Moore. Can I have parties announced for the record for the state?
Lauren Espinosa for the state.
Meredith should come for Mr. Moore.
And are you Mr. Moore? It's a bold move coming around with a Boston Red Sox. You know, I don't know how people feel about that. I used to love Pittsburgh, but mainly because of the uniforms.
Okay, the Pirates, yeah.
Oh, yeah, they used to have the nice caps. I even had my mom buy me one. I shouldn't say I had her buy me one, but I begged for one. And I thought their colors were so cool. All right, counsel, have you received all discovery in each of the cause numbers?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And each cause number, did you review the application for community supervision with your attorney? Did you understand it? And did you sign it? Did you review the true bill of indictment in each cause number? And did you understand it? Counsel, do you waive the reading?
Yes, Your Honor.
State and the cause number ending 82, are you proceeding on the indictment as presented?
Yes, sir.
And in the cause number ending in 08, are you proceeding on the indictment as presented? Mr. Moore? And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, and the cause number ending in 08, you're charged with possession of a controlled substance penalty group 1 to 4 grams. That's a 3rd-degree felony. And the cause number in 82, you're charged with possession of a controlled substance penalty group 1 less than 1 gram as a habitual. If the state is able to prove up the enhancements, then that will, the punishment will be assessed as though it's a 3rd-degree felony. Range of punishment for both of those cases then will be 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? And each cause number, according to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The state is recommending community supervision and the cause numbers will run concurrently. Did you understand that to be the plea?
Yes, Your Honor.
Defense and state?
Yes.
Did you review the waiver of appeal paragraph in each cause number? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours community service restitution, participation in
Veterans.
VTC and MRT, and compliance with all conditions from those programs, from that program. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right. Then to each offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in the cause number ending in 8-2, to the enhancements, how do you plead? True or not true?
True.
State any evidence.
Yes, Your Honor. State offer states exhibit 1 and all attachments in both causes.
No objection, Judge.
All right, and you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
All right, court will find that defendant has knowingly and voluntarily waived. 8-2, the court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge, and he's already done the referral to Veterans Treatment Court. He's been accepted, and I believe his orientation date is June the 4th
Okay.
to enter the program. We just had to do the plea today.
All right. All right, you need to make sure you make all of those dates, okay?
Yeah.
And with regards to any drug use, if you think you're gonna use, if something's going on with your life, you gotta reach out to people, okay?
Yes.
And so do you have someone to reach out? Does he have someone?
I have a family.
All right, so sometimes people say sponsors work for them. What I can tell you is I represented people and it took them 6 months to find a sponsor, right? And the reason why is because sometimes your personalities don't mesh or something, but you really need to start doing that, okay?
And Judge, I'm giving him the referral outcome sheet to keep with him. It has the email and the phone number for John over at the Veterans Treatment Court.
All right, and cause number 2025 CR 009908, the court is going to find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. 200 hours of community service restitution. For every sober support meeting you complete, an hour will be deducted from your community service restitution. Yes. There is going to be a referral to VTC and the court will note that he's been accepted. There's to be, let me see. Do you have any minors that live in the home with you or no? And you have a place to stay? All right. For now, I'm going to do no unsupervised contact with minors. The conditions that I'm giving you, Veterans Treatment Court may change them after they evaluate you further, but this is what I'm giving you now, okay? There's going to be field visits 1 time per month until he's accepted, well, until he's officially entered VTC. Probation, is there anything else? All right, and this cause number is going to run concurrent with 2025 CR 009982. All right, and then we're gonna move into 2025 CR 009982. Sorry, Odyssey is doing the circle thing now. All right, in that case, as previously stated, the court is finding you guilty. The court is finding the enhancements true. And the court is going to sentence you to 10 years in the prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider with minors, 200 hours of community service restitution, again, deducting 1 hour for every sober support meeting that's completed, referral to Veterans Treatment Court. The court will note that you've been accepted. No unsupervised contact with minors, field visits 1 time per month until you're officially in the VTC. And this is to run concurrent with 2025 CR 009908. All right, in each of those cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction in each, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, okay? All right, we can go off the record. Here's the thing. You can do this. You're a former veteran, so you can do this. My brothers always tell me, once a veteran, always a veteran. So you can do it, but just make sure you stay in touch with people. And if you think you're not strong enough, you were strong enough to come in representing Boston Red Sox.
Yes, you are.
All right, and not the Texas Rangers or somebody. Oh, that's great. All right, good luck to you, okay? Are you originally from Boston?
No.
Okay, all right. Have a good one, okay?
Okay.
All right, the CLO is here for, I believe, Mr. Gonzalez. Is it Savalas? All right, if you can have your client come up, please. All right, we're back on the record in 2023 CR 922W State versus Joe Gonzalez the fourth. Could I have parties re-announce?
Brandon Prada for the state.
Jose Rocha for Joe Gonzalez. Ready, Your Honor.
All right, with regards to the motion to revoke, Officer Savalas, the defendant has pled not true to each allegation. Defense, any objection to the witness appearing by Zoom?
No objections, Your Honor.
All right, state, you may proceed.
Thank you, Judge. Good morning, ma'am. Can you hear me?
Yes, I can hear you.
Okay. Can you state your name for the records?
There's Ceballos?
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. And could you spell your last name for the record for the court reporter?
Yes, it's Cevallos.
All right, state, you may proceed.
Thank you, Judge. Officer Ceballos, how are you currently employed?
Yes.
How are you currently employed?
I'm sorry, I can barely hear you.
Does he have, yes.
Yeah, I have a buck now. Thank you.
I
Can you hear me now?
apologize.
That's okay. Officer Ceballos, can you hear me now?
Yes, I can.
Okay. How are you currently employed, ma'am?
I'm currently employed with the Berg County CSCD Department,
Okay, and CSCG, what is that?
Community Service and Corrections Department.
More colloquially known as probation?
Yes, sir.
Okay. So Officer Ceballos, how long have you worked with probation?
I've worked for about 4 years.
Okay, and are you currently assigned the probation file for a Joe Gonzalez the fourth?
Yes.
Okay, and are you in charge of that file?
Yes.
You have access to that file?
Yes.
Okay, are you a custodian of record for that file?
Can you define custodian of record?
Since you have access to it, you add to it, you're in charge of its storage and care, are you custodian of the file?
Yes, sir.
Okay, and is that file made in the ordinary course of business of the Bexar County Probation Office?
Yes.
Okay, are the things that are put in there made by someone with knowledge?
Yes.
Okay. So let me ask you, Officer Cevallos, what are what are the two conditions, condition number 2 and condition number 4 that are read to all probationers?
Condition number 2 prohibits the probationer from consuming any illegal substances, alcoholic beverage, and also asks the probationer to submit drug tests as instructed by the community supervision officer. And condition number 4 also instructs the probationer to report as instructed by their community supervision officer.
Okay. And to your knowledge, are those conditions regularly read to all probationers that are put on probation?
Yes.
Okay. Is there a record in your file that shows that Mr. Joe Gonzalez IV was read these conditions?
Yes.
Okay. Did he sign that?
Yes.
Okay. So let's move on to. So when someone submits to drug testing, is there a record put into the file saying that they submitted to drug testing?
Yes.
Are there records missing in regards to Mr. Joe Gonzalez?
Yes.
Okay. What are those records that are missing?
So he failed to submit drug tests as instructed, I believe I'm sorry, I don't have the actual date in front of me, but for the month of October and November.
Okay. And what about condition number 4? Remind me again, what is that?
Condition number 4 instructs the probationer to report as instructed by their community supervision officer.
Okay. And are there records missing in regards to Mr. Joe Gonzalez IV regarding condition number 4?
Yes, he did fail to report as instructed for the month of December 2025, January 2026, and February 2026.
Okay. And those records would be made if Joe Gonzalez IV actually attended those meetings or submitted drug testing, right?
Correct.
And those records are missing?
Yes.
So that would indicate to you that he failed to submit to drug testing and he failed to report during those months?
Correct.
Okay. Thank you so much, Officer Ceballos. We'll pass the witness.
Defense?
Thank you. Officer Ceballos, can you hear me?
Yes, I can barely hear you.
Is this better?
Yes, that's better.
Okay.
Mhm.
Ms. Ceballos, in those records, do you also have call logs?
Call logs as in them calling us or?
Yes, as in the probationer calling you, letting you know that there's been an issue with being able to make it to your 20 testing.
No, he did not communicate that. I don't have a call log for that.
Okay, but you do have a call log, right?
I'm sorry?
You do have a call log in your file.
A call log of him calling me for not being able to make it?
Any call log. So if somebody contacts your office, would you have that information in your records?
Yes.
Whether it be the probationer or another police officer, for example.
Correct.
Okay. And do you have any of those calls logged in your records?
No.
Okay. Can a probationer check in with you for the month through the phone?
No.
How is it that they need to be checking in?
He needs to be checking in face-to-face contact here at the probation building.
Okay. And if something happens, do you contact the probationer?
If something happens in regards to what?
And it's in regards to the reporting period.
Yes.
Right. Is he scheduled on a certain date?
Yes.
Okay. What was that date for the month of October?
For the month of October, give me 1 second. So it's my understanding he did not report for the month of November.
Okay, but my question is whether,
Oh.
when did he report in October?
Oh, in October? I don't have access to that right now.
Okay, so do you have access for it for November?
I don't.
Okay, how about January?
So for January, he did not report.
Do you have access for January?
Yes, in the case file, there would be access.
Okay, and do you have access for February?
Yes,
Do you have access for December?
yes.
Okay, but you're missing October and November?
I am missing December, January, and February. December
Okay.
2025, January 2026, and February 2026.
Just so that we're clear, Ms. Ceballos, you said that you do not have access to check on which day he was to report in October, correct?
I do have access to the case.
But not that particular piece of information, right?
What particular piece?
The one that you said that you didn't have access to. On which day was he supposed to be reporting?
December, January, and February.
Which day of the month of October was he supposed to be reporting?
Give me 1 second. Let me check. So for October, he reported October 17th of 2025.
Okay, so now you do have access to that, correct?
I do have access, correct.
And on that, in October, did he drug test for you?
For October, he did not.
Did you ask him to drug test?
Yes.
Okay, and why was he not offered a drug test in October?
He was instructed to submit a drug test in October.
Okay, the same day that he went to go and check in with you, right?
Correct.
And he did check in with you, right?
Correct.
So then where is the test, the drug test for October when he was in your office?
So we don't conduct drug tests in the office,
Okay, where are the drug tests conducted?
at the drug lab.
Okay, where is the drug lab?
It's Recovery Monitoring Solutions.
How far away is it from the probation department?
It's about a 5-minute commute.
Okay. Walking or driving?
Driving.
Okay. And he had a appointment at the drug lab that particular day, correct?
Correct.
And for the month of November, is he normally checking in on the same day or around the same time?
Yes.
Okay. And prior to that, for the prior 2 years, did he always check in person?
I'm sorry, did you say for the past 2 years?
Yes.
I was not his supervision officer for the past 2 years.
When did you become his supervision officer?
I became his supervision officer May of 2025.
Okay. So from the month of May until December, every single time that he checked in with you, it was in person? Or not?
Correct. Correct.
He couldn't have just called you and said, hey, I'm checking in with you.
He cannot.
Pass the witness, Your Honor.
Very quick, redirect judge. Officer Ceballos, for the drug tests that were missed in the month of October, November, and the failed to report for January, February, and December, was there any call, email, text message, anything like that from Mr. Gonzalez giving a reason as to why he missed the appointments?
Yes, he was informed of his failure to report, and he was provided with a rescheduled appointment. I sent a letter and I also sent a text message to the probationer.
Okay. Did he, from looking at the file, did he ever attend those rescheduled appointments?
No, sir.
Okay, so no reason was given as to why he missed these appointments.
Correct.
Thank you. Pass the witness, Judge.
Any further questions?
No further redirect.
Any other witnesses?
No, Judge, state rest.
No
Any
witnesses, Your Honor.
All right. The court is finding violations 2, 2, and 4, and 4 true. The court is going to grant the motion, find you guilty, revoke. I'll hear argument as to what both parties are requesting.
Thank you, Officer Ceballos.
Judge.
Thank you.
I'll reserve for a moment.
Yes, what are you requesting?
Your Honor, my client would like for you to reinstate him into probation. He has been doing his classes. He has completed SATF. He has been making payments. We had this hiccup of reporting and the rescheduling. My client still to this day sustains that he was in contact with the probation office. He did call. He was making sure that he was on top of things. And what he's looking for today, Your Honor, is for him to be able to be reinstated and follow any conditions that this court might feel that it would
This
be
isn't
best.
his first motion to revoke.
That is correct, Your Honor. This is the third motion to revoke.
Okay. All right, what are you asking for, state?
Judge, we're gonna be asking for the maximum 2 years state jail. The reasoning for this is that this is the third NCR. He has stretched the patience of the court and everyone else around to its limits. And he has been.
Oh, well, he hasn't stretched my patience.
Of course.
I'm here to listen to whatever information people bring to me.
And he's been. His third NTR. With no call, no show for 3 months, and he failed to submit to drug testing before that. And because of that, Judge, we're gonna ask for 2 years state jail.
All right, court is gonna sentence you to 2 years in the state jail facility, give you credit for any time served, credit for any inpatient treatment. There's to be no unsupervised contact with minors. And I'll ask for the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Yes or no?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you for appearing by Zoom on short notice. CLO Savalas. Have a great rest of your day.
Thank you, you too.
All right,
Thank you, ma'am.
Thank
Thank
you.
you. Bye-bye.
Yes, thank you. All right, court is going on recess. It's 12 o'clock. And we will be back at.
This courtroom hearing started like any normal morning. Jokes about Taco Tuesday, people checking in, attorneys preparing cases. But then the atmosphere completely changed when one defendant stood before the judge facing years in prison. The woman admitted she repeatedly failed drug testing while on probation. One after another, the violations were read into the record, and each time she quietly answered, true. At first, the judge tried to understand what happened, why she stopped reporting, why she ignored the court's orders, why she kept making choices that pushed her closer to prison. Then came the moment that hit the entire courtroom hard. The defendant admitted she knew she would fail the drug tests, so instead of showing up, she simply avoided them altogether. The judge looked frustrated, not just angry, but disappointed. She reminded the defendant that treatment programs, probation officers, and the court had already given her multiple chances to turn her life around. But despite all the help, nothing changed. And then the judge said something chilling. If you don't change your life, you're going to end up going back and forth to prison, or somebody may end up identifying your body. The courtroom went silent. Instead of yelling, the judge spoke directly about addiction, overdose, and the reality of what happens when someone keeps going down the same path. She warned the defendant that drugs don't care about second chances. and one bad decision can permanently destroy a future. In the end, the judge revoked probation and sentenced her to prison. But even after handing down the punishment, the judge still tried to push her toward recovery programs and treatment opportunities before it was too late. Because sometimes the harshest courtroom moments aren't the sentences themselves. It's when a judge realizes they've run out of chances to give. Do you think the judge was too harsh? Or was this the reality check she needed?